Ladies and gentlemen, please welcome the Roseville Wrecking Ball. The Roseville Wrecking Ball.
Joshua Shrum. He is a very talented steward, very knowledgeable.
The Roseville Wrecking Ball. This is one of those podcasts where I listen to every episode. I love what he's putting out there.
The Roseville Wrecking Ball. Josh Shrum.
Parcels of Knowledge. Does a fantastic job with that podcast.
The Roseville Wrecking Ball. He is an Article 8 scholar, and thank God. We need Article 8 scholars right now.
Tune into the Parcels of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.
Good morning, and welcome back to Parcels of Knowledge, that podcast dedicated to delivering knowledge to the city letter carrier with your host, the Roseville Wrecking Ball. Today, we are going to pick up where we left off in terms of defenses to discipline. Today, we're going to be talking about particular defenses to discipline. But before we get into it, let's talk about the fact that we're going to have Howard Komine here on Saturday. Saturday is the first day of my route count inspection, so it's going to be a pretty fun one. But Howard Komine is going to be on the podcast. He's running for trustee for the CLC slate. And you can email me any questions you want at rosevillewreckingball@yahoo.com, and he will answer them. I need questions. Please send me some questions. It always works out the best when I get a ton of good questions. So feel free to take a second, think about the questions you want to ask, something that a trustee would need to answer to. Or if you want to get to know Howard, ask him anything. So send those to rosevillewreckingball@yahoo.com. That'll be in the description below. So let's take a look here. I think this episode, which is part 2, is mostly going to focus on particular defenses. So we're going to go through defenses that are very specific. Defense number 1 for section 2. So defense number 1 is management failed to properly investigate before imposing discipline. Before the decision to impose discipline is made, management must conduct a full, fair, and impartial investigation, including giving the letter carrier an opportunity to respond to the charges. The JCAM describes this obligation as follows. Article 16, Section 1. Principles. Before administering the discipline, management must make it an investigation to determine whether the employee committed the offense. Management must ensure that its investigation is thorough and objective. This is the employee's day in court privilege. Employees have the right to know with reasonable detail what the charges are and to be given a reasonable opportunity to defend themselves before the discipline is initiated. Defense to discipline number 2. Discipline was ordered by higher management rather than the grievance immediate supervisor. The decision whether to impose discipline and the decision as to the degree of discipline to be imposed should be made by the letter carrier's immediate supervisor. While higher authority may advise, if asked, it is improper for officials above the immediate supervisor to initiate discipline or to override the immediate supervisor's recommendation as to the extent of penalty. A particularly straightforward and easy-to-prove form of this violation occurs if higher management issues so-called blanket discipline instructions. For example, in C-16-436, the district manager issued instructions that any violation of a safety rule or procedure must result in disciplinary action. Also, see the article on blanket discipline in the spring 1998 NALC activists. All right, so it gives a few case examples. Defense number 3. Higher management failed to review and concur. While it is up to the immediate supervisor to initiate disciplinary action, before a suspension or removal is imposed, Article 16.8 requires that it be reviewed and concurred in by a higher level management. Article 16, Section 8, Review of Discipline. In no case may a supervisor impose suspension or discharge upon an employee unless the proposed disciplinary action by the supervisor has first been reviewed and concurred in by the installation head or designee. In post offices of 20 or less employees, or where there is no higher level supervisor than the supervisor who proposes to initiate suspension or discharge, the proposed disciplinary action shall first be reviewed and concurred in by a higher authority outside such installation or post office before any proposed disciplinary action is taken. JCAM explains Article 16.8 as follows. Concurrence is a specific contract requirement to the issuance of a suspension or a discharge. It is normally the responsibility of the immediate supervisor to initiate disciplinary action. Before a suspension or removal may be imposed, however, the discipline must be reviewed and concurred in by a manager who is a higher level than the initiating or issuing supervisor. This active review and concurrence must take place prior to the issuance of the discipline. While there is no contractual requirement that there be a written record of concurrence, management should be prepared to identify the manager who concurred with a disciplinary action so he or she may be questioned if there is a concern that appropriate concurrence did not take place. All right, on December 3rd, 2002, award by the NRLCA, National Arbitrator Eichen, concerned Article 16, Section 6 of the National Agreement. That provision is the same as Article 16.8 of the NALC Agreement, except it contains a requirement that the concurrence must be in writing. All right, so moving on. Defense number 4. Denial of representation or Weingarten rights. Federal labor law in what is known as the Weingarten Rule gives employees the right to representation during any investigatory interview which he or she reasonably believes may lead to discipline. The Weingarten Rule is discussed in JCAM under Article 17. The Weingarten Rule applies only when the meeting is an investigatory interview, when management is searching for facts and trying to determine the employee's guilt or decide whether or not to impose discipline. They do not apply when management calls in a carrier for the purpose of issuing disciplinary action, for example, handing the carrier a letter warning. An employee has Weingarten representation rights only where he or she reasonably believes that discipline could result from the investigatory interview. Whether or not an employee's belief is reasonable depends on the circumstances of each case. Some cases are obvious, such as when a supervisor asks an employee whether he discarded deliverable mail. The steward cannot exercise Weingarten rights on the employee's behalf, and unlike Miranda rights, which involve criminal investigations, the employer is not required to inform the employee of Weingarten rights. Employees also have the right under Weingarten to a pre-interview consultation with the steward. Federal courts have extended this right to pre-meeting consultations to cover inspection service interrogations. In a Weingarten interview, the employee has the right to a steward's assistance, not just a silent presence. The employer would violate the employee's Weingarten rights if it refused to allow the representative to speak or tried to restrict the steward to a role of a passive observer. Although ELM Section 665.3 requires all postal employees to cooperate with postal investigations, the carrier still has the right under Weingarten to have a steward present before answering questions in this situation. The carrier may respond that he or she will answer questions once a steward is provided. The Weingarten Rule does not apply to some situations. Article 16, Section 2 provides for minor offenses by an employee discussions shall be held in private between the employee and the supervisor. Such discussions are not discipline and are not grievable, so an employee does not have Weingarten representation rights during an official discussion. It should be noted that Article 17, Section 3 also provides the following. If an employee requests a steward or union representative to be present during the course of an interrogation by the inspection service, such request will be granted. All polygraph tests will continue to be on a voluntary basis. This rule is generally less broad in scope than the Weingarten rule, since it only applies to interrogation by the inspection service, whereas the Weingarten rule applies to investigatory interviews by any supervisor. Nevertheless, it should be cited in addition to the Weingarten rights whenever it is violated by management. All right, so continuing on. Section 2B, procedural disputes concerning the discipline issued. Defense number 5. Management failed to follow principles of progressive discipline. Article 16.1 requires that discipline be corrective in nature rather than punitive. Almost all arbitrators have read this to mean that for most types of misconduct, discipline must be progressive. However, management may skip minor forms of discipline for certain offenses which are normally dischargeable by themselves. For example, theft of mail. When management fails to follow the progressive path, arbitrators will usually disallow or modify discipline. Although Article 16.1 has implicitly required that discipline be progressive, the specific term was first used in 2001 National Agreement. Article 16.4, which concerns suspensions, now provides in relevant part that these disciplinary actions shall, however, be considered to be of the same degree of seriousness and satisfy the same corrective steps in the pattern of progressive discipline as the time-off suspensions. The JCAM provides the following explanation of progressive discipline. Corrective rather than punitive. The requirement that discipline be corrective rather than punitive is an essential element of the just cause principle. In short, it means that for most offenses, management must issue discipline in a progressive fashion, issuing lesser discipline for a first offense and a pattern of increasingly severe discipline for succeeding offenses. The basis of this principle of corrective or progressive discipline is that it is issued for the purposes of correcting or improving employee behavior and not as a punishment or retribution. City Carrier Assistant Exception. The Dennis Interest Arbitration Award created an exception for CCAs. He wrote concerning CCA discipline that while in any such grievance the concept of progressive discipline will not apply, this discipline should be corrective in nature. Typically, we would use that corrective in nature to try and say that it should be progressive because, of course, what's the point of going straight to the end? All right, defense number 6. Discipline was not timely issued. When management discovers a letter carrier's misconduct, it must initiate discipline in a timely manner. The discussion of just cause in the JCAM states that this rule as follows. Disciplinary actions should be taken as promptly as possible after the offense has been committed. If management does not initiate discipline in a timely manner, it waives whatever rights it may have to impose the discipline. It is not clear exactly where the line is drawn between timely and untimely discipline. A letter of warning for a 5-minute extension of a break issued several months later after the event would obviously be untimely. However, a removal 2 weeks after the mail was discarded might be found timely, particularly where management spent the 2-week period investigating to make certain that it had all the facts before it acted to impose discipline. All right, so defense number 7. Disputes whether grievance conduct, if proven, would constitute a proper basis for discipline. One of the fundamental principles of just cause is that discipline can only be issued for violating a valid rule. See the JCAM page 16.1. Sometimes management issues discipline for behavior which may not be properly characterized as misconduct, either because the behavior violates no rule or because the rule is invalid. Of course, a rule needs to be written to be a valid basis for discipline. Sometimes the rule is understood or implied. There is no written rule against throwing mail at the supervisor in anger, but doing so would undoubtedly be a valid basis for discipline. Although the opportunities to employ this defense are infrequent, it is the proper defense in certain recurring situations. For example, management sometimes disciplines employees simply for failure to meet the 1808 casing standard. As discussed under failure to meet standards below, such a charge does not form a valid basis for the imposition of discipline. Similarly, letter carriers have been disciplined simply for being bitten by a dog, But being bitten by a dog is not misconduct. It is an occupational hazard. Absent proof that a specific rule was violated, for example by failing to carry a satchel, such a charge will be insufficient basis for discipline. Defense number 8. Insufficient or defective charges. Article 16 requires that management give a letter carrier written notice of charges when imposing a suspension or discharge. Implicit in this requirement is the notice of charges describes and explains the basis for the discipline with sufficient specificity that the letter carrier can make a defense. Defense number 9. Improper citation of past elements. Management may attempt to improperly cite or rely upon past elements in support of disciplinary action. Generally, the improperly cited past elements fall into one of the following categories, and each will be discussed separately below. Job discussions, expired discipline, expunged, settled, or reduced discipline, and unadjudicated discipline. All right, so improper citation of discussions. Discussions specifically provide that discussions may not be cited as an element of prior adverse record in any subsequent disciplinary action against an employee. They may be, where relevant and timely, relied upon to establish that the employee has been made aware of their obligations and responsibilities. When job discussions are improperly cited, arbitrators sometimes order the discipline rescinded or modified. All right. Improper citation of expired discipline. Article 16.10, Employee Discipline Records. The records of a disciplinary action against an employee shall not be considered in any subsequent disciplinary action if there has been no disciplinary action initiated against the employee for a period of 2 years. Upon the employee's written request, any disciplinary notice or decision letter will be removed from the employee's official personnel folder after 2 years if there has been no disciplinary action initiated against the employee in that 2-year period. The JKM explains in this section as follows. The purpose of Article 1610 is to protect employees from having their past record considered when they have shown over a 2-year period that they have performed their job without incurring any further disciplinary action. Additional information on the retention and disposal of discipline records may be found in Handbook AS 353. A notice of discipline which is subsequently fully rescinded, whether by settlement, arbitration award, or independent management action, shall be deemed not to have been initiated for the purposes of Article 16.1 and may not be cited or considered in any subsequent disciplinary action. The 2-year limitation on the citation of records begins when it is initiated, not when it is served. See, for example, C-9469 Regional Arbitrator Martin, who held that management improperly considered as a past settlement a long-term suspension which was initiated more than 2 years earlier, but which ended less than 2 years before. The subject discipline. Issues concerning the application of Article 16.1 to last chance agreements are discussed separately. Improper citation of expunged or reduced discipline. Discipline that has been expunged by a grievance settlement or arbitration award may never be cited as a past element of discipline. In situations where discipline has been modified or reduced by a grievance settlement or arbitration award, only the record of a modified discipline may be cited as a prior element. For example, management may not write in a disciplinary letter that a letter carrier was issued a 14-day suspension, later reduced by a settlement to a letter warning. In such situation, management may only write that the letter carrier was issued a letter warning. Citation of unadjudicated discipline. Under the national agreement, an arbitrator may not consider past discipline that has been grieved but not yet resolved or adjudicated. C-3910, National Arbitrator Fasser. This does not mean that management may not cite unadjudicated discipline as a past element of discipline. It may do so, but at its own peril. If the cited discipline is later reduced or expunged, management may have a more difficult time demonstrating that any later discipline relying upon it as a prior element was progressive and issued for just cause. Furthermore, If the later discipline reaches arbitration first, an arbitrator may not consider the prior unadjudicated discipline. This situation often arises in removal cases, such as Article 15.4.b.4 requires that removals and suspensions of more than 14 days receive scheduling priority. The JCAM explains this rule as follows. The parties agree that arbitrators may not consider unadjudicated discipline cited in disciplinary notice when determining the propriety of the disciplinary notice. When removal cases are scheduled for a hearing before the underlying discipline has been adjudicated, an arbitrator may grant a continuance of hearing on the removal case pending resolution of the unadjudicated discipline. The contractual protection against arbitrators considering unadjudicated discipline does not apply to MSPB proceedings, which have a different procedural rule. Defense number 10, double jeopardy. Management may not twice impose discipline for a single act of misconduct. Thus, to issue both a letter of warning and a 7-day suspension for the same rollaway accident would be improper. It is not properly subjecting a letter carrier to double jeopardy, however, when subsequent discipline is issued for the same misconduct for which an emergency suspension or an indefinite suspension has been issued. The subject of double jeopardy is also thoroughly discussed in El Khoury and El Khoury, how arbitration works, which should be also consulted if necessary. Complicated double jeopardy issues have arisen where the Postal Service reissues discipline that had been thrown out by an arbitrator because of procedural irregularities. Most arbitrators hearing grievances concerning reissued discipline have held that this constitutes impermissible double jeopardy because the first arbitration award was final and binding. However, in one case, approximately 20 years ago, the Postal Service was successful in getting a federal court to vacate an arbitration award in such circumstances. Defense number 11, failure to give grievance rights. All discipline issued under provisions of Article 16 must advise the recipient of grievance appeal rights or it is procedurally deficient. See National Arbitrator FASR C2968. The weight that arbitrators will attach to this procedural deficit will ordinarily depend upon the consequences to the recipient of the discipline. For example, if an employee fails to grieve a letter of warning because he or she was not informed of or was unaware of appeal rights, an arbitrator will probably waive time limits for appeal. If, on the other hand, the employee was aware of his or her rights and filed a timely grievance, an arbitrator will probably not attach great significance to the procedural deficit. All right, Section 2C, Management's actions during processing of a grievance. Defense number 12. Management refused to disclose or provide information to the union, including claims that information was hidden. Article 15.2 of the JCAM requires the parties to fully disclose all arguments and facts at the grievance levels prior to the arbitration. JCAM states on page 15.5, the Postal Service is also required to furnish to the union, if requested, any documents or statements of witnesses as provided for in Article 17.3 and Article 31.3. Article 31, Union Management Cooperation, provides that Postal Service will make available to the union all relevant information necessary for the processing of a grievance. The JCAM's explanation of this rule states that the union has a right to any and all information which the employer has relied upon to support its position in a grievance. When a case file management fails to provide requested information to the union or hides relevant information, the union shall be prepared to argue the violation of due process rights. All right, defense number 13. Article 15, its management's grievance representative lacked authority to settle the grievance. Article 15 specifically confers upon management's grievance representatives full authority to resolve any grievance. Where it can be demonstrated that management's representative lacked authority, discipline has sometimes been overturned. This defense is closely related to defense number 3, where higher management has initiated discipline. It is presumed that subordinate supervisors lack the authority to settle. Defense number 14. Management failed to meet or failed to render a proper grievance decision. Article 15 requires that management meet to discuss grievances and state certain information in its grievance decisions. Failure by management to meet or to state that information has sometimes resulted in the overturning of the contested discipline. Although revised provisions of Article 15 in the 2001 National Agreement make it more difficult for management not to comply with these requirements, problems still occur. For example, if management refuses to meet and discuss a grievance at the informal A, the union steward is deprived of an explanation of management's position, which makes it more difficult for the union to present and prove its case. Section 3, Mitigation. All right, allegations that, because of mitigating circumstances, the discipline imposed is too harsh or no discipline is warranted. Mitigation defense number 1. Grievant may have acted improperly, but did so as a result of, lack of, or improper training, including claims that the grievant didn't know it was wrong. A letter carrier should not be disciplined for violating a rule of which he or she was not aware. It should be noted, however, that the employees are presumed to know the major rules of the shop. This defense will not be useful where, for example, the grievant has assaulted a customer or has intentionally discarded deliverable mail. Defense number 2. Grievant was desperately treated. Letter carriers who are similarly situated should receive the same discipline for the same misconduct. For example, if 2 letter carriers with no prior discipline extend their lunches by an hour, management might be able to justify giving each a letter warning. In the same situation, management could not justify giving one a letter warning and firing the other. This is given to you by, was the severity of the discipline reasonably related to the infraction itself, and usually administered as well as the seriousness of the employee's past record. Desperate treatment is an affirmative defense where the union must prove not only that other employees received a lesser penalty, but also that they were similarly situated. All right, so next we're going to roll into mitigating defense number 3. Rule grievant broke was otherwise unenforced. If management routinely permits letter carriers to violate a rule or routinely to follow a certain behavior, it may not suddenly impose discipline for violations without first announcing its intention to begin enforcing the rule or to stop tolerating the behavior. Mitigation defense number 4. Grievant has had a long prior service, good prior record, or both. As a letter carrier works the job year after year, he or she establishes ever greater property rights to the job, and a letter carrier with many years of service deserves a more moderate response to a transgression than does a new hire. This defense is most effective when the years of service have been relatively discipline-free. All right, so mitigation defense number 5. Grievance misconduct was not intentional. Unintentional misconduct is generally viewed as being less serious than intentional misconduct. Intent is an essential element of almost all charges of misconduct, and it is clear that it is management's burden to prove that the grievance acts were intentional. Mitigation defense number 6. Grievant was emotionally impaired. This is a subcategory of mitigation defense number 5 above. Here it is argued that the grievant was emotionally impaired, and because of that impairment, the grievance misconduct should be viewed as unintentional. Mitigation defense number 7. Grievant was impaired by drugs or alcohol. That includes claims that alcoholism was the cause of the grievance misconduct. This is a subcategory of mitigation defense number 5 above. Here it is argued that the grievant was impaired by drugs or alcohol, and because of that impairment, the grievance misconduct should be viewed as unintentional. This defense is used frequently, only rarely, however, is it presented with the thoroughness of preparation required for a satisfactory result. If you determine that this defense may fit a case which you are preparing, carefully study the case listed below and make certain that you can match the elements essential for a win. If you can't, you may be better off concentrating your efforts on other defenses. This defense is strengthened by Article 35, Section 1 of the National Agreement, which states in relevant part, an employee's voluntary participation in the EAP for assistance with alcohol and or drug abuse will be considered favorably in disciplinary action proceedings. Mitigation defense number 8. Grievant may have acted as charged, but was provoked by another. This defense is one of the only possible defenses to some forms of misconduct, including assaults on supervisors, customers, or other employees. In this defense, the union argues that even if the grievant acted as charged, the conduct should be excused or the penalty mitigated because the conduct was provoked by another. This is an affirmative defense. This means that if the union employs this defense, it bears the burden of proving that the provocation occurred. Thus, for example, if a letter carrier punches a supervisor, the union must prove that the supervisor first attacked the letter carrier and that the letter carrier was merely defending him or herself. All right, so that pretty much sums it up for all the defenses I wanted to go over. The rest of the defenses to discipline goes over different parts of the grievance procedure, steward's rights and steward's role, and things of that nature. There's a lot here I didn't discuss, a lot here I didn't disclose, but that's for a good reason. I think that everybody should actually download a copy of this handbook themselves if they feel like they want to go over this information. It should be more hands-on, and it should be more in-depth than, a few hours on a podcast. So go download Defenses of Discipline. It can be found on NALC.org. And if you want citations for a particular discipline, maybe you heard something that aligns with something that I was talking about, you can go to that section. For example, if I say defense number 3, such and such, and you think that fits your case, there's going to be plenty of C documents that are included as citations in these defenses to discipline that will help you prove your burden. Go there, read the documents, use them to defend your position, relate them to your case, make it fit your case, use the arbitrator's words in your situations, and build yourself a formidable defense. Of course, make sure that you go out there and go to your email me some questions to Howard Komine, of course. He's running for NALC Trustee. Email those questions at Rosevillewreckingball@yahoo.com. I'm going to put that in the description. Hopefully you learned something valuable today. And as always, have a good day.
If these guys are getting educated, we will be in big trouble.
Management's been weighing you down like a bag of wet catalogs, but you don't gotta take it. You strap on the elbow of education, dig it?
Ladies and gentlemen, please welcome the Rosevillewreckingball. The Rosevillewreckingball.
The Rosevillewreckingball is an Article 8 scholar, and thank God, we need Article 8 scholars right now. The grievance genius and the Rosevillewreckingball doing amazing work.
Tune into the Parcels of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.